What's up, freedom lovers? Jeff Lauder here, your favorite criminal defense attorney out of Orlando, Florida. Today, we're going to dive deep into the statutes. So if you're not interested in going deep into it, go ahead, watch another video. I'll put a link to one right up here or over there. Not sure where it shows up. But we're talking about statutory interpretation on a traffic crash DUI in Florida. Here's the deal. Florida statutes allow for an officer to make a misdemeanor arrest in only a limited number of circumstances without a warrant. They're called the misdemeanor exceptions. There's like 21 or 23 of them. Criminal mischief, battery, possession of marijuana. But the statute does not allow an officer generally to arrest someone unless they witness the misdemeanor take place in their presence. So you can't arrest somebody because, hey, I saw him driving down the road recklessly yesterday, so take him to jail today. The officer actually has to witness the event take place, or he has to obtain a warrant if it's a misdemeanor. Now, like I said, there's 23 exceptions to that. The appropriate statute in this case is 316-645 that says an officer that conducts an investigation at the scene of a traffic crash may make an arrest when the officer finds a violation of the statutes. Here's the facts. My client, lady, is driving down the road and weaving back and forth. The 911 caller calls in, anonymous, and says, hey, this lady's driving crazy. She's crashed into a couple barricades. So by the time the officer gets there, there's no witnesses on scene. My lady's still in the car, and essentially he arrests her after doing field sobriety test. Field sobriety, she's tore up, so there's no argument there. But he never goes back to the scene. He doesn't know what she hit. He knows she hit something. She's driving on 4 rims. Her bumper's fallen off. But he never identifies what she actually hit or where she hit it. And there's no allegation that there's a leaving the scene. There's no allegation that she's fled. There's nothing along those lines. And there's no witnesses. So my argument is this. In order to effectuate that arrest, the officer must have made an investigation at the scene of a crash or at the scene of the crash. And since he never went to the scene of the crash, he does not have the statutory authority to follow through with that arrest. So everything after the arrest should be suppressed under the exclusionary rule, fruits of a poisonous tree. We've talked about that in prior videos. I'll link a video up with the exclusionary rule right over here or over here. I'm not sure where. And you can check that out. Here's the problem. This argument requires a strict interpretation of the statute. It's clearly defined in there. Clearly, I am accurate with regards to reading the text of the statute. But I don't think that's the spirit of the statute. And so now the argument's going to be before the judge for strict interpretation. And if you follow along with Supreme Court stuff, this is a Judge Scalia, Anthony Scalia argument that you have to comply with what the statute says. You can't infer what the statute intended if it's not ambiguous. And if you don't know what ambiguous means, that just means there's multiple interpretations of something. So I could read this and it could mean one thing, but it could easily mean just the other thing. So if a statute's ambiguous, then it allows the judge a lot more leeway to interpret what it means in context with other statutes and other portions of that chapter, including definitions and case law. But if the statute is not ambiguous, at that point in time, there should be no grounds for the judge for interpretation. Now, I tried a similar argument. It wasn't an argument about traffic crashes, but it was an argument about a blood draw that had a very similar, very nook and cranny, small argument to be made that was factually accurate. And this was in a conservative county where they're definitely pro-police. So there the judge kind of said, great argument and good job, but I don't care, denied. I wish we could appeal it, but that's a whole nother issue altogether. So that's my concern here is, does the judge understand, recognize, and appreciate my argument, and then despite understand, recognizing, and appreciating the argument, still deny the motion in the first place? So that's at 1:30 today. It's going on 9 o'clock right now. So I'm going to do some preparation, do some last minute organization, and maybe I'll do a follow-up video with that. So it's 1:25 and my motion's supposed to start in 5 minutes, and yet I'm sitting in the car just drinking my Dunkin' Donuts coffee. I'm not sponsored, but maybe they should be. Hey, think about that, Double D. And the motion's not going today. And the reason why is because we worked out a deal. Didn't get a chance to present that argument like I wanted to. I think it's a fascinating argument. However, emailed out to the state to briefly discuss the motion before we got involved. I knew she was coming off of a long week. She had back-to-back jury trials, which is just mentally exhausting. And it's Friday afternoon. The judge doesn't want to be there. The prosecutor doesn't want to be there. I don't want to be there. And so I was able to use that entire circumstance to get my client offered a reckless driving. And the client, she was all about it. You know, she just doesn't want to have a DUI on her record. She's willing to suffer all the penalties. She just doesn't want a DUI on her record. She'll do whatever. Emailed out the prosecutor. The prosecutor said, let me reach out to the officer. Officer said, I'm cool with whatever. And we worked out a deal. So now there's no court this afternoon. The case has been set out. We have another hearing, not on this case, but we have other cases in that courtroom next week. Told the client she has to be there for the plea. We haven't finalized all the exact terms, so there's still a little bit of negotiation going, but we've got the core down that it's going to be a reckless driving, alcohol related, and that takes away the mandatory minimum punishments on a DUI case. Anyways, God bless, guys. Have a great weekend. Appreciate you watching. Bye-bye.